Welcome to Litigation Finance 101. My name is Wendy Childress, and I'm an investment advisor for Validity Finance. Thank you for joining me today. Before we get started, I'd like to go over the agenda for this program. First, we will discuss what commercial litigation finance is for those in the audience who may not be familiar with it. We will discuss how litigation finance benefits both firms and their clients. We'll touch on how the process works and how a party or a firm can go about obtaining litigation finance. And finally, we'll cover various ethics issues that arise in the context of using funding. So to begin, what is commercial litigation finance? Litigation finance is any transaction in which a litigation claim or an arbitration claim is used to secure financing from an outside party. The financing party comes in and provides capital to a claimant in exchange for an interest in the outcome of the case. The financing is provided on a non-recourse basis, and as such, the funder that finances the claim only receives a return if the case is successfully settled or it results in a collected judgment. If the case is unsuccessful, the client owes nothing. So how do funders invest in litigation? There are primarily 5 ways. The first, fee and cost funding, is the most common. This involves the financing party providing capital to pay for all or a portion of the attorney fees and costs for a claimant to bring a claim. If that case is successful, the funder receives a return from the proceeds of the case, along with, of course, its principal. The capital is typically provided across the life of the case. So as fees are incurred or costs are incurred, particularly for expert witnesses, the funder receives the invoice and pays a portion of or all of those fees and costs. A second way that funders invest in litigation is through portfolio funding. In portfolio funding, the funder provides capital directly to a law firm or to a client. But rather than just a single case, the collateral for funding is a number of cases, usually 2 or more, bundled together rather than just one case. Any of the case proceeds that come in, or if the funding is provided to a firm, contingency fees that come in are what are used to pay the funder's principal and return. And that repayment occurs as those cases in the portfolio resolve. Really, whichever case resolves first, the funder is beginning to receive their principal and a return back. And often the funder is able to recoup its full return and principal from the resolution of the first cases in the portfolio, leaving the law firm or the client to be able to recoup the full amount of the case proceeds as later cases resolve. A third way that funders invest in litigation is by providing clients working capital. Sometimes clients, for various reasons, may need an infusion of capital during the pendency of a lawsuit, which the funder can provide. This enables the company to invest the capital into growing the company or simply sustaining operations during the years-long litigation. A fourth way that funders invest in litigation is through defense funding. So like fee and cost funding that we discussed for a single case, here the financier comes in and provides fees and costs to a firm or to a company for a defense side case or to defend litigation. This can be done in several ways. The first would be through a hybrid portfolio, which would contain a mix of defense side and plaintiff side cases. The funder would be able to come in and provide fees and costs across the portfolio of cases, but would negotiate the return of its principal and a return from proceeds that resulted from the plaintiff side litigation. Another way to do this is for the funder to provide the fees and costs in a case where the firm has negotiated a success fee upon certain triggers or milestones in the litigation, and the funder is able to negotiate its return from that success fee rather than what is traditional, which is the proceeds of litigation.